Good morning, everyone. My name is Betty Donelley, Law Offices of Betty J. Donelley, and I am an attorney specializing in contract, real estate law, and mortgage finance. And I welcome you this morning to our seminar, How to Manage Litigation and or Stay Out of It. So I want to get started. First of all, I always have what I call the shuns of legal disputes. First one is negotiation. And why is that really important? Well, it's the first thing you do when you get involved in a real estate contract. You negotiate the contract, and you're negotiating on behalf of your client, or if you are the party involved in the contract, you've entered into negotiation with the other party. It is also the subject of legal disputes. So, it's very, very important. As a realtor, you're involved in negotiating for the price, the terms, the closing date, as well as what's included in the purchase price. If it's a loan transaction, you're going to be negotiating the interest rate, prepayment penalties, the fees, costs, time, terms, maturity dates. So it's really, really, really important that everybody understand that negotiation is that first process in resolving a legal dispute. What's next? Mediation. Mediation is going to be required even if you decide to retain an attorney and go to court. Why? Because the courts require a mandatory settlement conference. It's called an MSC. And before you are ever going to see trial, you're always going to be required to attend a mandatory settlement conference. So, okay, the guy's in the back in here now. Mandatory settlement conference. And a mediation. And what happens with the mediation is both parties will go in front of a mediator, and it's a choice you have, and you will present your side of the issue. The other party will present their side, and the mediator's job is not to make a decision for you. The mediator's job is to get the two parties talking. That's what mediation is. Get the two parties talking and see if you can't come to terms with a settlement. And the reason why mediation is because our courts are loaded with psychopaths and criminals and people, gangs, and people that we've got to get off the street. So the courts say, look, you are all adults. You entered into these contracts as adults. You knew what you were doing. You negotiated a contract. Why then can you sit down at a table as adults and resolve your problems? We got too many people who can't figure out their left foot from their right foot, and we got to take care of these guys and get them off the street. Okay, that's mediation. What about arbitration? You're familiar with arbitration. You're familiar with arbitration clauses in the contracts and in your purchase-sale contracts, right? Contracts have both binding and non-binding arbitration. Why would you choose non-binding arbitration? Well, non-binding arbitration, you have a right to go in front of an arbitrator and, again, present your side of the story, your case, in front of a neutral arbitrator. Both parties have the opportunity to look at a list of arbitrators and choose one neutral arbitrator. So if you see someone on that list that you don't like and you know is probably not going to rule in your favor, you can eliminate that person. And you both parties come together and say, okay, we agree on this person to hear arbitration. Now, why would you go to non-binding? Because it's a glimpse of a mini-trial. That's what it is. It's going to be like a mini-trial. You're going to come in, you're going to present your evidence, you can have a witness, and you're going to tell the arbitrator your side of the story. Initially, you're going to have to actually file papers with the arbitrator well in advance of the hearing in order for the arbitrator to know what the case entails. So the arbitrator needs to know what the dispute entails, and it's up to you to try to show the arbitrator in advance what you're going to prove at the arbitration hearing. It's a glimpse without the cost involved. Now, why would you go to binding arbitration? Well, again, it's a cost-saving factor. It's also, this arbitrator is a person who has been selected either through the American Arbitration Association, through JAMS, or some other arbitration organization. This is all they do. They listen to disputes, and they arbitrate the matter. So why would you accept the binding? Because it is going to be as a jury trial, as a judge trial might hear it. Okay, you don't have the costs involved, and it's quicker, and there's something in the law that says you can be right, but how much do you want to spend to prove your rights? Okay, so it can cost you, and you can be right. You can say, gee, I'm going to do it for the principle of it. Well, that's great. If you've got the time, the money, and you don't mind the mental duress you're going to go through, then you can do that process. Well, what's the last one? What's the last shun? And it's the very last one, so you may want to think about that for a test question, litigation. Okay, litigation is what's going to happen. It's your last step. There are three areas that you can work with in the law. One is going to be the first step in litigation would be small claims court. The small claims court, the amount of the claim cannot exceed $7,500 or $5,000 for business. You need to make sure you serve the defendant or the other party in a proper service, and you cannot be represented by an attorney. So this is your day to shine. Okay. If you're the plaintiff and you lose, you may appeal. You may not appeal. If you're the plaintiff, you lose, you're done. That's it. If you're the defendant and you lose, you can appeal, and you appeal, you go to superior court. So you go to the next court, and at that time, both of you can be represented by an attorney. Okay, what's going to happen when you go to small claims? How many of you been to small claims before? Okay. I used to be the queen of small claims. I used to have my chair in Santa Barbara, and, it didn't matter what it was, whether my transmission guy didn't fix my transmission or landlord-tenant disputes, but I have to tell you, here's what's going to happen in small claims. Each party is going to go in, and guess what's going to happen? The first thing is, yes, all parties have to be there. You're going to let the judge know you're there. And what's the judge going to say? How many of you would like to mediate your dispute? You're going to be asked to do that. So they're going to say, go out and try to get this over with and try to talk to each other and resolve your problems. Because if you do, you're not going to go to the end of the line. We're going to bring you right back in here and put you right up next person whose case is going to be heard. So there's an advantage to it. Not only that, you want to raise your hand and tell the judge, pick me, yeah, I want to go do that. Why? Because the judge may remember you. And it's going to show the judge that you really do care and you really do want to try to resolve your problem. So it's always a good thing, and you're not going to lose your place in line. Okay, what happens if you can't come to a resolution? You're going to go in. If you're the plaintiff, you're going to present your side of the story to the judge, and if you're the defendant, you will have your turn next. You don't interrupt each other, because judges don't like that. You will have your time to talk. Now, for both sides, I can't stress enough, this is what you want to do. You go in, if you're a plaintiff and you say, here's where it says in the contract, you're going to need to have a copy of that contract, but make sure that whatever you're talking about, you've got one for the judge too. And you make sure that the judge has a copy of that contract, and you're going to highlight the sections of the contract that you think are pertinent and that you don't want the judge having to dig through a contract later on because